In the case of U.S. versus Houlihan, we are asking the question about whether a person's statement of intent to do something with another person is admissible as evidence that the speaker actually did it with the other person as a hearsay exception under a then existing state of mind. Now, we knew from the Hillman case that Walter's statement, "I plan to go to Crooked Creek with Hillman," was admissible to show that because Walters planned to go to Crooked Creek with Hillman, he was actually in Crooked Creek. Hillman was a side note in that story because all we cared about was proving that Walters was in fact in Crooked Creek. In the Houlihan case, what we're trying to show is that the speaker in this case, Boynton, that he actually met Billy Hurd. Boynton ends up dead, and we want to implicate Billy Hurd in the crime. And one of the links in this chain is to show that the victim says, I'm going to meet Billy Hurd later tonight. Now, the problem with that is that we're kind of stretching the doctrine of state of mind exception when we say because you intend to do something, that's some evidence that you will do it. You put something on your calendar, that's some evidence that you will have done it at the time when you say you're going to do so. It's another thing to say, I intend to do something with a person. If I say, I plan to mow my lawn tonight, my lawnmower doesn't have to agree with this. My lawnmower can't develop other plans. So with inanimate objects, our intent to do something in the future is not really bad evidence that we're going to do those things or have done those things after that time has passed. But what about when we're talking about meeting other people? It might be one person's intent to meet another person. It might have been Boynton's intent to meet Billy Hurd, but that might not have been Billy Hurd's intent. It might have been that Boynton was bragging about the fact he was going to meet Billy Hurd. Maybe Billy Hurd was a famous gangster in the area, and Boynton wanted to seem important to his friends, boasting that he was going to meet him. There could be all kinds of reasons that a person's statement of their intent to do something with another person is not really all that predictive of the fact that the future event happened. But yet, the Houlihan case is discussing only the circuit split that exists, whether you have to have corroborating evidence to show that your statement of intent to meet another person actually was consistent with what happened. Do you have to have something that corroborates the fact that this meeting occurred or was going to occur? Is it also on Billy Hurd's calendar, for instance? Do you have to have that corroboration? That's the only thing at issue in this case, not whether it's appropriate to admit as hearsay a person's statement of future intent to meet another person. That's admissible in every jurisdiction in the country. You can always show that a person's statement of intent to meet another person is their state of mind, intending to do so, and therefore some evidence that the meeting occurred. Some jurisdictions, however, will require that evidence, or that there be evidence of corroboration that the meeting occurred, whether it's from a statement of intent by the other person, or whether it's someone thought they saw them together, or someone saw Billy Hurd driving in the direction of the meeting. Some courts will require corroboration. The Massachusetts court in the Houlihan case, however, says, we've considered this circuit split, and we don't think you do need corroboration based on the fact there's nothing mentioned about corroboration in this particular rule of evidence. So the big takeaway from the Houlihan case is this: the Hillman doctrine is extremely powerful. You can use it not only to show that if you can use a person's statement to show his or her current state of mind, and that state of mind is the intent to do something in the future, you can show that the person acted consistent with that intent to do something in the future, not only when it involves travel or activities that involve just the speaker, but you can also offer those things that go to a person's state of mind that shows intent to do something with other people to show that there was actually something done with other people. Again, it's not conclusive. All we're asking with rules of evidence is whether a jury can hear some piece of evidence to prove a particular proposition. And the Houlihan case furthers the Hillman case and says if one person says something that illustrates their state of mind, their intent to meet another person in the future, a lawyer, a party can offer that statement that shows state of mind of intent to meet another person in the future as some evidence that that meeting occurred. That would also go to, I plan to meet Billy Hurd to rob a bank. You could offer that statement to show as some evidence that the activity that the person planned to do with the third party also came to pass. It's not conclusive, and certainly itself wouldn't be enough for a conviction of bank robbery. But you can absolutely show, and this is why the Hillman doctrine is so broad, you can absolutely show things that show state of mind that are about a person's desire to do something in the future as evidence that that thing was done in the future alone or with other people, with or without, in some jurisdictions, any corroborating evidence that the other people were actually involved.